the primary complaint associated with candidate Ryan's papers are that he misled voters and misrepresented to signers the purpose of the petition. I've outlined in the memo some discussion of what occurred during the 2011 recall petition circulation and rather contentious board meetings at that time. It should be noted that in the sections of the statutes dealing with nominations of candidates and in the administrative code provision associated with treatment and sufficiency of nomination papers, there is no similar statutory or administrative code provision to what exists in the recall statute, and that is the ability to strike signatures because the purpose of the petition was misrepresented. So that's the first hurdle that we have. The second hurdle is the type of evidence that was presented in this circumstance, and that it in staff's opinion, doesn't meet the clear and convincing evidence necessary to rebut the presumption. We in addition to receiving the complaint, we did get contacted by another individual who sent very similar information. And what's interesting about all of this is that in nearly every reference or every Facebook post or what have you, the writers of these items have some mention of one of the platforms that candidate Ryan is working for is the legalization of marijuana. Candidate Ryan?
Yeah.
And so, you know,
Yeah.
yes,
Yes,
there certainly are some photos of people holding a sign next to where candidate Ryan is obtaining signatures, and that sign says, you know, legalize marijuana. They likely were circulating a petition for it at the same time.
You're referring to Jeremy Ryan?
Correct. And so there is some mixture of activities that they're doing, but candidate Ryan, Jeremy Ryan, has filed a verified response sworn statement indicating that he made it absolutely clear that his nomination papers were for getting to the ballot for running for Congress for the 1st Congressional District. One other thing to point out from the 2011 recall period, not that I want to relive that, but one of the emphasis that board members made associated with those recall petitions was the writing on the petition document itself, where it has a statement for those that are signing it, indicating that they understand the purposes of it. In the circumstance of a nomination paper, it clearly says on the top, nomination for partisan office in bold, black writing. It has the candidate's information all over the top. There's no dispute that the candidate information and the heading on these nomination papers weren't in some way deficient. And then it has a big long statement saying that I am nominating the person for ballot access, and I'm not going to sign any other candidate's nomination papers. And in 2011, the board was struck by the detailed written language on recall petition pages that would identify the purpose of the petition, and that it seemed incredulous that people wouldn't understand what they're signing. I think the same applies here, but even more profoundly, in the sense that everything on this page is talking about nomination. And even if there's some speech associated with the nomination drive that might be promising, say, lower taxes, less government, legalizing marijuana, gay marriage, whatever it may be, that it's incredulous to assume that that somehow improperly induced people to sign the petitions. And many of the nomination papers also have campaign material on them, and some could argue that some of the promises made in that campaign material falsely induced somebody to sign the nomination paper. And I think that's why the legislature particularly stayed away from this type of ability to strike signatures based on that, both for free speech purposes, but also just the difficulty of proving it. So in signing as circulator for his nomination papers, staff doesn't believe there's any clear and convincing evidence that candidate Jeremy Ryan knowingly and willfully signed a certification that was false under 12.13 sub 5. So staff is recommending that all of those challenges be denied. There are a number of other challenges that the complaint makes that staff has addressed in detail, and we did find several that we recommend the board do sustain, and they're itemized on page 22 in great detail. But this still leaves, because it's only 13 signatures, still leaves candidate Jeremy Ryan with 1,100 valid signatures according to staff, and we recommend that the board verify that total, accept the challenges or sustain the challenges that are identified in the proposed motion, deny the misrepresentation or fraud challenges, grant ballot access, and direct staff to prepare an order.
Ms. Rulon?
Honorable judges and staff, thank you for the opportunity to come before you today as a representative of the Republican Party in challenging Mr. Ryan's nomination papers. In our complaint, you will find numerous sufficiency issues with individual signatures, which I won't get into the specifics of because I would rather draw your attention to the first point in our complaint regarding the allegations of misrepresentation in collecting nomination signatures by Mr. Jeremy Ryan. Our allegation is that Mr. Jeremy Ryan knowingly and willfully circulated his nomination papers and obtained signatures under false pretenses by intentionally obscuring the content of the nomination papers, by promoting and luring signers into believing they were signing a petition to legalize marijuana rather than a nomination paper for partisan office. That is, individuals were signing the nomination papers for a purpose other than what they were led to believe. You have before you in our complaint an article labeled Exhibit BBB, which is basically the very last page of the complaint, or the last 3 pages of the complaint, explaining in greater detail the way in which Mr. Ryan improperly gathered the signatures. In that article, you will find a since-deleted Facebook post describing a conversation a Democratic campaign worker had with a Kenosha resident who had been asked to sign Jeremy Ryan's nomination papers under false pretenses. According to the Democratic campaign worker, Jeremy Ryan and others set up a sign depicting a large marijuana leaf that on the sign said, legalize marijuana or legalize pot, sign here. The words sign here were on the sign, as well as legalize pot. The campaign worker describes an interaction between himself and a Kenosha resident that makes it clear that Jeremy Ryan presented his nomination papers as a petition to legalize marijuana. Additionally, when a campaign worker actually confronted Mr. Ryan and his associates regarding the purpose of these papers, they packed up and left in a hurried manner, according to that Facebook post. It's important to note that Jeremy Ryan was the sole circulator of all of his nomination papers, as you can see in Exhibits A through W, W, and C, C, C through E, E, which are all of his nomination papers. Pursuant to Section 8.15 sub 4, in a partisan primary, when a circulator signs a nomination form, he is attesting that each signer, and I quote, knows they signed the paper with full knowledge of its content, end quote. He admits in his own affidavit that while collecting signatures, he held a sign reading, legalize marijuana, sign here, and that his explanation of the papers may have, and I quote, gone in one ear and out the other, end quote, of some signers. His own affidavit plainly acknowledges that he is not certain that the signers had full knowledge of the content of what they were signing, and he does not deny the presence of a sign calling for signatures to legalize marijuana. Again, he provides evidence that he certified the nomination papers in violation of Section 8.15 sub 4 sub A, because he could not attest to the full knowledge of the electors or the signers. Beyond his violation of Section 8.15 sub 4 as a circulator, Jeremy Ryan has violated Section 12.13 sub 3 sub A that prohibits an individual from falsifying any information in respect to a nomination paper and prohibits an individual from filing a nomination paper knowing any part is falsely made. In summation, Jeremy Ryan knowingly and intentionally falsified the circulator's certification of his nomination papers in violation of both Chapters 8 and Chapters 12 of the Wisconsin statutes, and therefore all of his signatures are invalid, and he is ineligible to be placed on the ballot. Beyond just that support for our complaint, I would like to address a couple points made in staff recommendation. One, staff brings to the attention of the board the Chapter 9 of the Wisconsin statutes governing the evaluation of recall petitions, and I would just remind this board that those statutes are an entirely different framework than what is before the board today regarding Chapter 8 and nomination papers, and also to the point that staff makes that Chapter 8 does not provide the same misrepresentation language that is available in Chapter 9 of the statutes. I would just make this board aware that even though there is not such a provision in Chapter 8, the certificate of the circulator set forth in Chapter 8.15 sub 4 sub A, as well as on the face of the GAB's provided nomination paper for partisan office example. These statutes and this paper specifically require a circulator to certify that he or she is aware that falsifying the certification is punishable under Chapter 12, specifically Section 12.13 sub 3 sub A. Consequently, this election fraud under Chapter 12 is appropriate for this board to consider during this challenge process regarding the validity of signatures. Finally, just one more point, I have some concern regarding the way in which respondent's affidavit was drafted. I noticed not only that in the staff's recommendations that the staff indicates that Mr. Ryan's affidavit basically mirrors their recommendations. Also, I find that the affidavit was notarized by a staff attorney and division administrator within the GAB. And I'm not an expert in this area of law, and I'm not entirely sure what exactly happened, but I think that these two factors call into question the drafting of this affidavit, and at very least it warrants additional investigation because the GAB is ultimately the final arbiter on this issue.
Are you suggesting staff conspired with Mr. Ryan in drafting both the board memo as well as his affidavit?
No, I'm not alleging that. I'm saying there's some concerns, and I don't know, like I said, I'm not an expert in this area of law, and perhaps there is not an issue with a staff attorney from the GAB notarizing, but I just think it is concerning that there is so much overlap with the staff's memo and the actual affidavit, and I just think it warrants extra investigation because of the fact that the staff recommendation is based on this affidavit, and the GAB is the ultimate arbiter.
It's supposed to be investigated by
the GAB, Your Honor.
Does that complete your presentation?
Yes, thank you.
Would it be possible for staff to put a copy of one of the nomination papers up so we can read it?
Sure. doing that, I'd just like to point out with Representative Bernier's challenge, same language was used with respect to the response that Representative Bernier filed, in that I specifically wrote in the memo that her response tracked staff's recommendations. It was shorthand for not having gone through in great detail every bit of the response, in that it essentially came to the same conclusions we did.
Can you blow it up so we can see what the undersigned are think they're doing?
Right in the middle there, Judge. Underneath
The part that says, I, the undersigned, request that the candidate whose name and address are listed above be placed on the ballot at the election described as a candidate representing the party, etc., right? And then they allege that they're eligible to vote in this district.
Where's the marijuana part?
I don't see that.
You'd have to look at the Facebook pictures and stuff. Mr. Ryan will probably have a chance to address that.
Would you like me to pass around the attachment to the complaint? I have color. Is it color though?
I have the verified complaint. I have Mr. Jeremy Ryan's affidavit here. I'm not sure where the marijuana part is.
I don't think that attachment is.
Okay, let me. I'll hand it around to the board. We've got a color. Yeah. This one's in color.
Mr. Falk, you've just handed me 3 colored sheets. Are these, where did these come from?
That's an exhibit attached to the complaint. It's the last article, last exhibit that Ms. Ruin mentioned when she was discussing.
I see. Okay, so we did not get this particular exhibit. Is that something that came from a Facebook page, according to the complaint?
No, that's actually a website. We've got like 4 levels of hearsay here. So if you turn to the last page, there is where the Facebook post is commenting on it.
Okay.
No, he didn't say that. Yeah. But it's in black and white. Okay. We can pull it up on the screen. Actually, it looks like that last statement is a comment to the article citing something this person saw on Facebook. So that's, the 3 or 4 levels of hearsay and stuff.
Are there any other questions of the last speaker? Because if not, we give Mr. Ryan a chance to speak. Mr. Ryan.
I would first like to just dispute this claim. It is true I did hold a sign that said legalized marijuana sign here. It's an issue that a lot of people can relate to, and an issue that will draw people to you in order to sign the papers. And I don't see anything wrong or illegal with that. When an elector would come up to me to sign the petition, I would clearly let them know this is to get me on the ballot to run against Paul Ryan for Congress. And in my first term, if elected, I would introduce a bill on the federal level to legalize marijuana. It is a platform idea. You're not misleading anybody. Signing for me would be a step towards legalization of marijuana. And most people still signed. There were a couple that were like, no. In addition, I would just like to reiterate that all of my information and what they were signing was clearly on the sheet itself. And then finally, the article that's being evidenced as proof is essentially just hearsay, as has been said. And the Facebook post, the original Facebook post by Larry Zamba, is a campaign staffer for an opposing campaign, which makes it even more suspect. And then on top of that, the article even notes that the Facebook post was deleted. It was deleted by the time they wrote the article. And the reason for that is because I had contacted Larry as soon as I had heard that these allegations were being made against me, and about a week before the signature collection period was over. And I said, look, Larry, this is completely baseless. I would like to have you come join me for collecting signatures, and you can see that I'm not misrepresenting anything, and that I can still get 100 or 200 signatures in a day easily. And he said, okay, I will. He had some personal issues come up and wasn't able to, but he has later, there was another article by the same heavily biased publication where he's later backtracked and said, no, I don't stand by my claims anymore. And so not only is it just hearsay, but the original author has even backed down from it. So, you know, much like most of what the Republican Party of Wisconsin says, I find this claim has no merit.
If I could just make two additional points. One that Division Administrator Haas wanted me to point out, and that is the issue of the notary signature on complaints and documents that come into the office. If you look at the majority of the documents that were processed in this nomination cycle, an overwhelming number were notarized by staff in the office, by the attorneys in the office, by individuals in the office that have their notary. Just wanted to point that out for the board. Additionally, on the issue of Mr. Ryan's complaint looking similar to the recommendations, I was the initial person that had talked to Mr. Jeremy Ryan after we had sent him notice of the challenge. That's the standard procedure. We make sure that they received the complaint. And in my conversations with Mr. Ryan, he said he had pretty much already had drafted his entire response and was stopping over to the office in about an hour or two to drop it off. So the allegation that somehow we were working with Mr. Ryan or something to come up with a recommendation for the board is not correct, and I wanted to point that out. Thank you.
Is the board ready to act?
I think the complaint is absolutely meritorious. Welcome to big time politics, Mr. Ryan. And I think the claim that somehow there was collusion between the staff and Mr. Ryan is despicable. And I am going to move that we approve the recommendation by staff.
Is there a second? I'll second the motion. Discussion? All in favor signify by saying aye.
Aye.
Opposed? No. The ayes appear to have it. The ayes have it. Motion passes.
Thank you.